maybe we should pause to examine whether campaign finance laws actually advance the democratic values we think they do. Corrupt. Maybe what we should be doing is taking time to ask, did we get the fundamental rules right to actually address corruption in government? Unethical. If the Supreme Court regularly invalidates campaign finance laws because of constitutional problems, maybe we need to think about whether campaign finance laws are viable whatsoever. Bought and paid for by corporations. Just challenging campaign finance law often means you're going to be treated like the heretic, someone speaking against that one true faith. But I want us to take some of our emotions, some of our feelings, and that's what it is that drives campaign finance, feelings. Let's set them aside for a moment, and let's do a little deeper dive into the role of money in politics, and let's start by exploring some of the top myths that surround the blockbuster case, Citizens United versus FEC, case that I was proud to be involved with its outcome. The first big myth that arises, and what a misunderstanding that most people have about the case, is that Citizens United allowed corporations to be able to give money directly to candidates. Nothing could be further from the truth. In fact, we still have a long-ranging ban on corporations and unions being able to give money directly to candidates. The Citizens United case was about a film no one wanted to see, Hillary, the movie, and whether the federal government had the power to be able to ban a group from being able to publish it in America. Now, today, as we analyze that, that's about the right of a corporation or a union to be able to engage in what's called independent expenditures, a type of speech under federal election law. It has nothing to do with direct monetary exchanges with candidates or anyone else. The second general myth and misunderstanding of Citizens United is that it was the first time the Supreme Court recognized the personhood of corporations. Corporations are not people. You will hear this sort of rally cry against Citizens United. But that's legally not true. Ever since the 1800s, even earlier in some instances, we've recognized corporate personhood. And in one of the Supreme Court's blockbuster free speech cases, First Bank versus Bellotti recognized corporate rights in the same sort of a setting. So why is this? Well, there's two principled reasons why we extend a sort of personhood to corporations. The first is that corporations are nothing more than groups of people. So if you and me and a friend of mine get together, why would we lose our constitutional rights just because we formed a group to do something with a common goal? That would seem absurd. Second, we use all sorts of placeholders in the law. Corporations need to be something to enable for their legal rights to be respected. So they have to be able to enter into contracts. They have to be able to be held accountable. So we call them a person. It's a placeholder to say it's a legal fiction, just to say this is a responsible entity. It's like a person. So we shouldn't get all worked up that Exxon, Planned Parenthood, or the NRA are deemed people. They're groups of people, they have rights, and those rights need to be respected. Citizens United did exactly that and was correct in that holding. So a third big myth that we look at when we're talking about Citizens United is that the decision only benefits big corporations. Now that's absurd, because it applies to any sort of corporation that might want to engage in political advocacy. So that's the local nonprofit, because a nonprofit is indeed a corporation. A Big Brothers and Big Sisters Club, that's a nonprofit. The local barbershop, that's probably a small business corporation. We have over 33 million small business corporations in America whose free speech rights were affected by the holding of Citizens United. And not to mention groups like Citizens United that were a 501 either C3 or C4 who had speech rights stifled because they were in that category. So no, this isn't just about Exxon or Target or some large corporation going out and sharing their views. It's more about these small groups being able to do so. And by the way, large corporations want you to buy their products. They want you to buy their services. And they are very reluctant to wade into controversial issues and to upset half or more of their constituency and customers in doing so. Now, it's a long road on how we got to Citizens United. And what I want to do is just work through the passage of early campaign finance law and then talk about some of the early cases that start building brick by brick the rules here. And I think it's important to pay attention because, as with many things in federal law, we start with a good intention, let's end corruption, and we create sort of Frankenstein's monster. We create a labyrinth of rules that are very difficult to understand and a maze that we have to piece together. And it sort of grows out of proportion and it becomes difficult to apply. In the 1970s, we see the Federal Election Campaign Act enacted, and just after the Watergate scandal, we see amendments to it that give it some real teeth. And what the law is designed to do is limit the amount of money that individuals can give by means of contributions to candidates, but it also places limits on how much money you can spend for speech. It creates, for one of the first times in American history, an obligation, if you spend beyond certain amounts of money, to have to register and regularly report with the federal government for your speech activities. Now, in 1976, James Buckley, he's the brother of the renowned conservative commentator William F. Buckley from National Review. He's a senator from New York, actively involved in politics and in some litigation here and there. He brings suit because he finds it an anathema to the First Amendment that you would have to seek permission and regularly report and disclose your political dealings to the federal government. And he sees this as a violation of First Amendment rights. So Buckley works its way through the federal courts and gets to the Supreme Court. Supreme Court views it with a great deal of suspicion. It applies what it calls exacting scrutiny to the case. Near what we call strict scrutiny, a high level of rigor in terms of examining what's going on here. The court upholds contribution limits that apply to individuals, and it says whenever we're giving money directly to a candidate, we see a direct link for corruption, so we got to be concerned there. We'll allow government to police it. But in terms of putting a cap on how much you can spend for speech, well, that's like saying you're free to drive an automobile as far and as long as you want on one tank of gasoline. It doesn't add up. And so the Supreme Court invalidates any limits for money that you can spend on your own speech, and it upholds reporting and registration requirements that are attendant to this law. Now, in doing all of this, it creates, as the Supreme Court is prone to do, a complicated test. And it says that speech that is the express advocacy, that is, express advocacy are words intended for the election or defeat of a clearly identified candidate, that those can be regulated and you can require disclaimers and certain sorts of reports that have to be filed. But there's a whole host of other speech called issue advocacy. And that's things like this year, vote for the environment, call your senator, tell them you care about gun rights. These sorts of messages can't. And for the next 50 years, we have a string of messes developed from that standard trying to figure out what's regulable, what's not, and we're going to sort through that constitutional chaos right now. So the next big case is Massachusetts Citizens for Life versus FEC. This is a tiny nonprofit out of Massachusetts who puts together its own little newspaper flyer, and it has messages about voting for pro-life candidates. And the FEC comes at it to say that it should have created a political action committee, it should have filed all of these reports, and it's way past due and has all these civil penalties that are applicable to it. And Massachusetts Citizens for Life says, we're just a small group. There's no way that we can keep up with having to hire an accounting firm, having to engage in sophisticated reporting on a monthly or quarterly basis with the federal government. And so it challenges the burdens that are placed on it in doing so. And the Supreme Court recognizes this. It says, look, you have to have a major purpose of engaging in this sort of advocacy if we're going to put all of the burdens that the federal government imposes on an organization. So if you're primarily engaged in what we called issue advocacy before, then we can't require you to have this political action committee, a PAC. We can't require you to do all this burdensome paperwork. So that rule sets in, and we move forward to the next major case, which is McConnell versus FEC. Congress passes the Bipartisan Campaign Finance Reform Act in the early 2000s, and Senator McConnell and others bring a challenge to the constitutionality of it. Now, the BCRA creates a new definition in the law, and it says that there are things called electioneering communications. And what happened was Congress did a study and said, look, we think that there are really smart advocacy groups out there, and they often try to write their ads in a way that they're not express advocacy, that they're issue advocacy, and they're just so that they don't get regulated. And we think that that's a shame, and we think that we need to regulate this more. And so there were studies that were done in academia where they looked at what is the effect of these ads on college students. A whole host of college students, young adults, look at ads that are close on the line between express advocacy and issue advocacy. And they found that most young adults, most college students, had a very difficult time being able to discern this. And from this, Congress decides that there are too many groups trying to circumvent federal election laws, so we need to make the rules a little bit stricter, a little bit wider. We're going to reach more speech. An immediate challenge is brought to the regime addressing the constitutionality of it. That fails as it moves up in the courts, and the Supreme Court says, well, no, we had this express advocacy test before, but we're going to get it a little bit better, folks. We are going to create a functional equivalent of express advocacy test. Frankenstein's monster is growing. And Congress not only has the power to regulate express advocacy, but now the functional equivalent of express advocacy. How do we know what that is? Well, if ads talk about the character of a candidate, if they talk about his stance on issues, if they encourage you to vote, have a call to action. And so we're left with this sort of hazy standard that's now going to be applied in cases. McConnell versus FEC is good law for a few years, until we get to about 2007, when another small nonprofit, Wisconsin Right to Life, decides that it wants to air some advertisements about senators in the state and whether those senators have a sufficiently pro-life stance, and asking individuals to call those senators to adopt a pro-life stance on certain measures. Now, this new electioneering communications provision in federal law now regulates this sort of communication, because electioneering communications are ones that are done within so many days of an election. They have to reach a certain amount of the electorate, and they have to either name candidates or talk about these issues that are running in the campaign. And so these television ads that we would otherwise think of as being at the heart of the First Amendment, very protected speech, suddenly become subject to prohibition. And Wisconsin Right to Life brings the case to the Supreme Court. The Supreme Court is hesitant to strike down the prohibition entirely. What it does is it says, now look, we think the FEC got it wrong. We think that they made the regulations too far-reaching. In fact, the regulations, if you looked at them, allowed the FEC to do an examination into the intent and the effect of the speaker. So the FEC effectively has a crystal ball to decide why it is that people are speaking in the way that they are. And if the FEC thinks you're really trying to affect an election, they're going to find your speech to be prohibited. And again, if you're a corporation that is a nonprofit, like Wisconsin Right to Life, you're not allowed to go out and do that. That's now an illegal expenditure that you made. And when we think about that and weigh that against our commitment to allowing everybody a chance and opportunity to speak in that marketplace of ideas in America, that seems like a really bad idea to the Supreme Court. Okay, so through the decades, we start building these different tests around this express advocacy standard we talked about from Buckley. And we left off with McConnell and Wisconsin Right to Life, struggling with a functional equivalent of express advocacy test in the Wisconsin Right to Life case. So the FEC had this crystal ball approach where they assured the Supreme Court they could figure out what the true intent of speech was, which of course the Supreme Court rejected. But it got worse when it came to Citizens United, and I was actually at the Federal Election Commission when it wrote the regulations for what was at issue in Citizens United. And how the Supreme Court reflected on the FEC's approach here to what it could regulate as speech was to call it what I named it in the brief, a two-factor, 11-part balancing test. So for citizens to be able to figure out whether they could speak during an election, they had to consult this maze of tests, a labyrinth. And the Supreme Court said for an average citizen to comply with the law was just about as effective as a prior restraint, that is an absolute ban on speech, because they made it so complicated and so difficult and imposed the need to hire an expensive attorney to be able to wade through an advisory opinion process, to be able to weigh the many opinions of the FEC, just to know whether you're allowed to speak during an election. So the Supreme Court invalidated that, and it revisited prior precedent. First Bank of Bilotti had limited the rights of corporations to be able to speak, and so the most radical, if you will, nature of Citizens United was in its ability to say, we should never judge speech rights based on who the speaker is. So you're the big brother, big sister clubs, or you're Exxon, it doesn't matter. What we need to look to is what is the real governmental interest here? And there's no way that we stop corruption in America by shutting down people from speaking. Sure, wealthy speakers, wealthy groups might be able to speak and be able to put their message out there in a louder, more reaching way than other organizations. But we also know when Americans really care about an issue, they get together in a collective forum. The NRA pools their resources and they let their messages be heard about gun rights. When Planned Parenthood is upset about choice issues, they pool their money, they protest, they lobby, they get their voices heard. And we have this back and forth, but what we don't do is cut out certain groups or certain elements in the process. And like I said before, this isn't just about big corporations. This ban applied to unions, labor unions as well, who were seen as inherently corrupt, and just the smallest of nonprofits. So at the end of the day, Citizens United is about overturning a speech ban. It's about telling one particular group of people in America that they're not allowed to run films, they're not allowed to run their own political advocacy unless you comport with a very difficult test the Supreme Court came up with. That's why during oral argument, Justice Alito raised the question about whether, if this law had applied to a book, did the U.S. Congress possess the power to be able to actually ban a book if it included one sentence that's from a corporation that said something to the effect of vote for John Jones. And the surprising answer was yes from the Solicitor General. That result simply can't be upheld in our American system of First Amendment jurisprudence, where we let everyone speak. America, you've been sold a bill of goods. From the very get-go, we've been promised that campaign finance reform is a way to clean up politics, to get corruption out of the system. But it's a top-down system. It favors entrenched powers. It makes it difficult to comply with the law. And that means that those in powers and those who are the incumbents are going to stay in their positions, whereas unregulated systems favor new entrants. They favor those who are able to figure out new ways to raise money and to be able to pool that together and have their voices heard. They also raise a whole host of constitutional problems. So we've worked through case law from Buckley v. Vallejo from 1976 all the way up to Citizens United just recently by the Supreme Court. We see time and time again deep, entrenched constitutional problems with the law. And we're entrusting a federal bureaucracy to be able to sort out precious, sacred First Amendment speech about engaging other Americans on issues that we care about. And they've shown time and time again that they cannot formulate a single coherent approach for doing so in a limited way that truly roots out corruption. We already have these laws in place. We have a system that works to be able to preserve that. Campaign finance is simply the wrong way to go. Unregulated systems allow for new challengers, more voices, and a diversity of opinion. I think that's something everyone can celebrate and should be our focus today.